On February 13th, Eric Loomis was found driving a car that had been used in a drive-by shooting. He was arrested and pled guilty to 2 charges, 1, attempting to flee a traffic officer, and 2, operating a motor vehicle without the owner's consent. Eric denied involvement in the actual shooting. It is now time for the judge to deliver a sentence. When thinking about what Eric's sentence should be, the judge considers how likely it is that Eric will commit crimes in the future. To help determine this, the judge looks at something called a recidivism algorithm. This is an algorithm that is meant to determine how likely it is that someone with a particular personal history will reoffend. The algorithm will take in information about Eric and spit out a 1 to 10 score. A score of 10 means that the algorithm believes that people like Eric are very likely to commit crimes in the future. A score of 1 means that the algorithm believes that people like Eric are not likely to commit crimes in the future. What could possibly go wrong? This is a story about statistics, justice, and discrimination. Eric here is about to go through a 4-year legal battle around the use of recidivism algorithms. He will claim that these recidivism algorithms violate due process by discriminating on the basis of gender and race. This short video is about how difficult it is to pin down a mathematical measure of discrimination, and how algorithmic tools currently in use may be endangering our constitutional rights. For the purposes of this video, I am going to focus on Loomis's claims about racial bias and racial discrimination, even though he raised both gender and race concerns in his due process claim. Keep in mind that many of the points raised in this video also apply to gender discrimination. So back to Eric's predicament. One of the first questions we might ask about this recidivism algorithm is what kind of information it takes in. For COMPAS, the software used in Eric's case, the answer to that is actually pretty straightforward. COMPAS takes in answers to 137 questions. Some of these questions are filled in based on criminal records, some are filled in by screeners, and some are filled in by the defendant themselves. Here are 5 questions that appear on the questionnaire that might raise some flags. Questions like, based on the screener's observations, is this person a suspected or admitted gang member? And how often did you have conflicts with teachers at school? Might be routes for personal bias to influence the score. If you have or had racist screeners or teachers, then the discrimination expressed by these people might affect how you are treated by COMPAS. Questions like, was your mother ever arrested? Is there much crime in your neighborhood? And were you ever expelled from school? Might also be routes for institutional and historical injustice to influence the score. For example, suspensions and expulsions particularly are well known to be racially biased, even controlling for the severity and type of violation cited to be the reason for the suspension. These are just 5 out of the 137 questions that COMPAS takes in. I haven't touched on the questions COMPAS will ask you about your friends, your finances, or your mental health, but I want to establish here that Eric is making a plausible claim of racial discrimination, even if none of the 137 questions are directly asking about race. But there are generally 2 big objections at this point. The first objection is the accuracy objection, which goes something like, what if all of these questions make the algorithm more accurate? Then, surely, nothing is wrong. The second objection is the insufficiency objection, which goes something like, this alone doesn't demonstrate that racial bias manifests in the actual scores. We do not know how the questions are weighted. It might even be that these questions are used in favor of historically marginalized groups. How can we tell? Both of these questions lead to some fascinating issues in statistics. The answer to the first objection relies on how we determine which statistics are relevant to which questions, and the role of accuracy in the evaluation of tools that affect public life. The answer to the second is going to involve a dispute between measurements of fairness and bias. Northpointe, the company that created this algorithm, is going to present statistics that, according to them, demonstrate that COMPAS is not racially biased. ProPublica, an organization of investigative reporters, is going to present statistics that, according to them, demonstrate that COMPAS is racially biased. The relation between these 2 fairness metrics is going to reveal how difficult fairness is to navigate. But let's take a look at the first objection. One form of this objection involves an appeal to objectivity. The statistics that underpin this model are the same statistics that predict earthquakes. Are we to say that earthquake prediction is discriminatory? This objection is pretty straightforward to address. Earthquakes and tectonic plates do not have rights. Predicting their behavior is not legally problematic, but people, in fact, do have rights, the potential violation of which is what we are examining. A broader challenge from this angle comes from trying to understand why it might be a good idea for courts to restrict the kinds of evidence they accept if that evidence will help accuracy. One way to address this is by considering pragmatic considerations of evidence. Imagine a police officer presents to the court a video of Alice stealing a television set. But the police officer acquired this video by breaking into Alice's house, tying her up, and torturing her until she told him where to find the video. The video might indeed help the court in an accurate judgment on whether Alice is guilty of theft. But we have pragmatic reasons to stop the court from accepting this police officer's evidence. We do not want to encourage or endorse illegal and inhumane actions in the name of evidence collection. Minimally, we have pragmatic considerations in the form of the due process rights, just like Eric is proposing. We also might have pragmatic considerations from things like trust and due dignity in the courts that might affect how we consider discrimination in law. A more complex objection rests on what kinds of statistics count as evidence. Imagine that you walk outside and find a sign that has "It is 70 degrees" carved into it. The sign never changes, it just says that it is 70 degrees every day at all times. Now, it just so happens to be that in the location that the sign is posted, it is 70 degrees around 80% of the time. It's a remarkably stable climate. Next to the sign is a thermometer, but the thermometer is a bit hard to read. The numbers are kind of smudged, but you can read the thermometer accurately about 80% of the time. You think it reads 70 degrees at the moment. So here we have two facts. The first fact is that a sign says it is 70 degrees, and it is 70 degrees about 80% of the time. The second is that a thermometer reads 70 degrees, but there is only an 80% chance that you read the thermometer correctly. Both facts give an 80% chance that it is 70 degrees outside, but is there any reason to prefer the sign over the thermometer, or the thermometer over the sign? Consider this. What if it were not 70 degrees? Then the sign would still claim that it is 70 degrees outside, and the knowledge that it is often 70 degrees outside also wouldn't change. But the thermometer is sensitive in a way that the sign and the general fact about the climate is not. The thermometer would have an 80% chance of giving you the correct temperature. So even though these two methods of measurement have the same accuracy, I might prefer the thermometer because it changes with the facts of what I am trying to measure. I might even be compelled to say that because the thermometer is sensitive and the sign is not, only the thermometer counts as evidence for the current temperature. The sign and the general fact about climate doesn't count as evidence because it would say the same thing no matter what the actual temperature was outside. In Eric's case, the algorithm might be quite accurate but not sensitive to the right kinds of relevant facts. How we decide which facts are relevant is complex, but if a piece of evidence is not sensitive to the relevant facts, then I might be compelled to say that this piece of evidence is not evidence at all. Accuracy be damned. It is trickier in this case because the judge and the algorithm are thinking about future acts, and future acts may be influenced by the current sentencing decision. But this worry that we have accurate statistical information that is wholly irrelevant remains a possibility. So to answer the judge's first objection, we have a few responses. First, if you think this is comparable to things like earthquake predictions, Eric's case is special, because Eric has rights that earthquakes and tectonic plates do not. Second, if you are thinking about the general principle that anything that helps with accuracy should be permitted, this ignores pragmatic considerations in evidence collection. Third, even setting aside all of this, it's not obvious that the statistical evidence we invoke is going to be relevant in the right ways for the questions we are asking. Let's take a look now at that second objection. This is going to be much more involved and unsettled than our last one. To make the math a little bit easier, instead of having a 1 to 10 score, I'm going to consider the case where an algorithm just has choose scores, low or high. This won't change anything substantial about what's going to be shown, it'll just make understanding a little bit easier. A low score means that the algorithm predicts that you are not likely to commit crimes in the future, and a high score means that the algorithm predicts that you are likely to commit crimes in the future. First, let's get familiar with the stacked bar chart. The chart here shows the outcomes for a hypothetical pool of defendants. Let's go over what we're looking at. The highlighted bar represents all of the black defendants who scored low on the algorithm. You can tell because each column is labeled with both a score category and a race category. The green part of the bar represents people who did not actually reoffend. Because it is in the first column, these are specifically black defendants who scored low who did not reoffend. Because it stretches from 10 to 50, there are a total of 40 people represented here who are low-scoring black defendants who did not reoffend. That red part of the bar represents people who did reoffend. Because it's in that first column, these are specifically black defendants who scored low who did reoffend. Here is a question to check your understanding. What does the highlighted part of the chart represent? I'll give you a few seconds to pause and think about it. If you said that this represents high-scoring black defendants who did reoffend, you are correct. If you're having trouble, remember that the red part of each bar represents the people in each category who did reoffend. Each combination of race and score is represented by a separate column. Here's another question to check your understanding. What do the highlighted parts of this graph represent? These are all of the white people who reoffended regardless of score. The two bars on the right represent all of the white people in this group. The red parts of those bars represent those who reoffended. One last question. According to this chart, how many people scored high but did not reoffend? The answer is 20. There are 10 high-scoring black people who did not reoffend, and 10 high-scoring white people who did not reoffend. So that is 20 total people who scored high but did not reoffend. Now that we understand this stacked bar chart, we can get to what Northpointe considers to be evidence that their algorithm is unbiased. I am representing them with that compass on the upper right. They point out that for every score, the proportion of black defendants who reoffend is about the same as the proportion of white defendants who reoffend. In short, for each possible score, low or high, the score indicates the same amount of risk whether you are black or white. We can check this on the chart. The highlighted portion are all of the people who scored low. Notice, 1 out of 5 low-scoring black defendants ended up reoffending. It's the same for our low-scoring white defendants, 1 out of 5. The same thing is true for everyone that scored high. 4 out of 5 high-scoring black defendants ended up reoffending, and 4 out of 5 high-scoring white defendants ended up reoffending. An intuitive way to see this as a fairness score is that this ensures that each score quote-unquote means the same thing no matter your race. No matter what your score, your race will not affect the probability that the prediction is correct. Here is another chart that Northpointe would consider fair. Let's check. For low-scoring black defendants, the proportion who reoffend is 1 out of 5. For low-scoring white defendants, the proportion who reoffend is also 1 out of 5. Graphically, this is represented by the green area and red area being proportionate for each column with the same score. The low-scoring black column looks just like a proportionally scaled version of the low-scoring white column. And let's check the high scorers. Just like before, the high-scoring black column looks like a proportionally scaled version of the high-scoring white column. That's how we can tell that for each score, the proportion of black defendants who reoffend is the same as the proportion of white defendants who reoffend. But there are two camps here. Let's look at why ProPublica thinks that this algorithm is in fact racially biased. I'm representing ProPublica with that striped P on the upper right. ProPublica notes that when COMPAS makes mistaken predictions, there are two kinds of mistakes it can make. The first mistake is to predict that they will not reoffend when in fact they will. That's the highlighted portion of the chart. These are all of the people who scored low but in fact reoffended. This is a mistake in favor of the defendant. They were predicted to not reoffend but in fact did. The second mistake is to predict that they will reoffend when in fact they will not. This is a mistake against the interests of the defendant. They were predicted to reoffend but in fact they did not. In this example, ProPublica is satisfied. They think that black defendants who do not reoffend should not be reported as riskier than white defendants who do not reoffend. Intuitively, ProPublica wants to make sure that when COMPAS makes mistakes, it doesn't make the mistake against the interests of the defendant more often for one race than another. Let's check this. Here are all of the black people who did not reoffend. 40 of them scored low, and 10 of them scored high. So if you are a black person who will in fact not reoffend, you have a 20% chance that the algorithm will make a mistake against your interests. It's the same thing for our pool of white defendants. Here are all of the white defendants who did not reoffend. 40 of them scored low, and 10 of them scored high. So if you are a white person who will in fact not reoffend, you also have a 20% chance that the algorithm will make a mistake against your interests. No matter your race, if you will not reoffend, the chance that the algorithm will make a mistake against you is 20%. That is what ProPublica considers to be fair. Here's another chart that ProPublica would consider fair. If you are a black person who will not reoffend, you have a 20% chance of the algorithm making a mistake against you. The highlighted green bar on the right is 4 times smaller than the highlighted green bar on the left, and that means a black person who will not reoffend will have a 20% chance to land in the high-scoring group. If you're a white person who will not reoffend, you also have a 20% chance of the algorithm making a mistake against you. Again, the highlighted green bar on the right is 4 times smaller than the highlighted green bar on the left. Unfortunately, in real life, the COMPAS algorithm violates this. COMPAS treats black defendants who will not reoffend worse than white defendants who will not reoffend. Here is a chart that reflects this. The actual COMPAS algorithm will assign a high score to black people who will not reoffend more often than white people who will not reoffend. The area highlighted in yellow are black people who will not reoffend. Proportionately, much more of them are getting high scores than white people who will not reoffend, who are highlighted in blue. Furthermore, not only does COMPAS tend to make unfavorable mistakes for black people, it tends to make favorable mistakes for white people. The area highlighted in yellow are black people who will reoffend. The area highlighted in blue are white people who will reoffend. Proportionately, much more white people are getting lucky and being assigned a low score than black people. This is the state of COMPAS right now. Note that we just showed that COMPAS makes favorable mistakes for white defendants and unfavorable mistakes for black defendants. But this very same chart satisfies Northpointe's metric. Recall, Northpointe cares that each score has the same rate of reoffense no matter the person's race. This is true here. If you score low, then no matter your race, you'll have a 1 in 5 chance of reoffending. And if you score high, then again, no matter your race, you will have a 4 in 5 chance of reoffending. So there's the rub. We have these two intuitively attractive fairness metrics, but they disagree under realistic conditions. The actual COMPAS algorithm satisfies only one of them and fails the other. In ProPublica's view, it's true that I don't want the algorithm to make worse mistakes for black defendants and better mistakes for white defendants. In Northpointe's view, it's also true that I want each score to mean the same thing no matter the race. You might be thinking the answer is clear. We should just require that algorithms satisfy both of these metrics. Surprisingly, this turns out to be impossible. It is impossible for ProPublica's measure and Northpointe's measure to agree. The problem comes with a single true fact about American recidivism statistics. Black people in America are more likely to reoffend than white people in America. This could be for any number of reasons. Police may be more likely to arrest black people than white people, judges and juries may be harsher on black defendants than white defendants, or one of those other biases we spoke about earlier could be in play. But no matter the reason, this one fact guarantees that Northpointe and ProPublica will never agree. In this chart, black and white people are just as likely to reoffend. There are 50 out of 100 black people in this chart who reoffended, shown in yellow, and 50 out of 100 white people in this chart who reoffended, shown in blue. Let's say I want to keep Northpointe happy, and ensure that each score means the same thing. How can I change this chart to reflect the fact that black people are more likely to reoffend? I can't just add a bunch of people who reoffended to one of the black columns, because that would throw off the ratio that Northpointe cares about. Low-scoring black people and low-scoring white people no longer have the same rates of reoffense. I have to proportionately stretch or shrink columns in order to keep Northpointe happy. If I stretch the first column, then the proportion of black people who reoffend will be less than the proportion of white people who reoffend. If I shrink the first column, then the proportion of black people who reoffend will be more than the proportion of white people who reoffend. The trend is reversed for the second column. If I stretch the second column, then black people will reoffend more often. If I shrink the second column, then black people will reoffend less often. So to adjust this chart to reflect the condition that black people reoffend at higher rates than white people, while keeping Northpointe happy, I have essentially only two options. I can either stretch the second column or shrink the first column. What if I take the option to stretch the second column? This keeps all of the ratios for each individual column the same, so Northpointe is happy. It also results in a higher proportion of black people who reoffend, while keeping the proportion of white people who reoffend the same. But notice what happened to black people who did not reoffend. They are now more likely to be labeled as high risk in error, while white people who did not reoffend are comparatively better off. What about our second option, to shrink the first column? This also keeps Northpointe happy and raises the rate that black people reoffend. But again, notice what happened to black people who did not reoffend. They are now more likely to be labeled as high risk in error, while white people who did not reoffend are better off. So no matter what we do, changing this chart to reflect the real-life condition that black people reoffend more often than white people results in Northpointe and ProPublica's fairness metrics coming apart. The only way to make Northpointe and ProPublica agree that a metric is fair is to have a world where base rates for reoffense are exactly the same for all races, as reflected in this chart here. This is troubling. We went through all that looking at the statistics behind why this algorithm might be racially biased or not, and it turns out that no algorithm will ever satisfy both. We can try to pull out a few takeaways. On one level, this isn't surprising. The world is filled with injustices, and so many biases influence both recidivism rates and the data that we pass on to COMPAS. Perhaps we were just naive to hope that a neat algorithm would satisfy all of our desired fairness metrics. We might also think that there must be something missing from these statistical arguments that is crucial in situating algorithms in courts. In COMPAS's favor, it doesn't necessarily need to be completely free from bias to be usable. It might be possible that it is less biased than judges. But many of the questions that go beyond these arguments require a closer look at the inner workings of COMPAS. But because COMPAS is owned by a private corporate entity, we can only see what is publicly available from its use in courts, and what Northpointe chooses to tell us. But COMPAS isn't even that accurate. I was very generous in presenting those charts. In reality, COMPAS gets it right about 65% of the time. This is worse than pooled judgments of individuals with no criminal justice background. In comparison, they are accurate 67% of the time. Is COMPAS worth the risk? Eric Loomis was sentenced to 6 years in prison and 5 years of extended supervision. The Wisconsin Supreme Court ended up requiring judges to be alerted to the potential dangers of these kinds of assessments. The Supreme Court did not choose to hear the case, and Eric's case stopped there. COMPAS is still in use, along with other pre-sentence investigation reports. Advocates hope that such reports will create a more objective sentencing procedure, but critics remain suspicious. The inner workings of COMPAS have stayed under Northpointe's control, and it looks like it is unlikely that the public will ever get to see how this algorithm really works. This is not the first or the last time courts will struggle with statistical evidence, algorithms, or fairness. Next on my list is McCluskey v. Kemp, a Supreme Court case about racial bias and the death penalty. It hinges on the difference between probabilities to do with groups and probabilities to do with individuals. Also in consideration, Sindel v. Abbott Labs, about proportionately distributing liability according to the likelihood of guilt. Thank you so much for watching.